Good morning.
Thank you so much.
Good morning, everyone. That was unexpected. Good morning and welcome to our fourth part of our workers' compensation adventure. You move that on. Right. So this presentation is going to be dealing with the complex and catastrophic claims. And we're going to go ahead and get started and talk about, first thing about our disclaimer. If you've attended any TAC training, you know that we are not, we're trainers, we're not legal experts, and therefore we're not going to be rendering any legal advice. So if you have any questions in a legal nature, we would refer you over to your county attorney or to a competent attorney that's familiar with your specific situation. You can always contact me and I can provide you guidance on how to get your answers. So, okay, so those of you who had attended all these programs, this is just going to be a small recap. And if you have not, I would recommend that you try to access the recording. Part one, we talked about starting an adventure as if it was a road trip. Because every claim is going to have a beginning and an end. And so we were going to view it like a journey. So in part one, we talked about what do you do when you're setting yourself up for a road trip. And it's very similar in how you're putting your workers' compensation program together. You want to set goals for yourself. You want to know where your resources are. You want to, train your staff. People are going to be working, interacting on the workers' compensation things. You want to set yourself up with an administrative policy. We're able to monitor those claims. So all those strategies were included in that first part. And then we moved to the second part. And where we actually talked about what a workers' compensation claim is, on what course and scope might be, compensability, the fact that we are a regulated industry, we've got timeline compliances, the definition of disability, which is a little bit different than what you might think it might be, how we do everything from calculating wages, average weekly wage, how salary continuation impacts the payments, and kind of let you know that sometimes things are not a very linear process. Sometimes we have to deviate. We have to pivot, make creative solutions. And those of you who have been involved in workers' compensation, I see a lot of familiar names up on the board. You know, you've been there, you understand that, but it's just kind of feeling, putting some structure to our program and understanding how the claim process works so that you have a greater feel for the overall program that the pool presents for you guys. Let's go to part three. In part three, we dived into building a return to work culture, how return to work culture is really important to getting those claims to conclusion as we start talking about the end of our journey. We want to make certain that you've got policies in place for light duty, doing bona fide offers. I know they're kind of a pain sometimes to do, but being consistent with your employees and holding them accountable with the bona fide offers is very helpful. It also helps us in the administration of workers' compensation. If we have a dispute situation, we have to go into adjudication. We talked about calculation. Now, one of the things we brushed on very briefly was the use of vocational rehabilitation through the Texas Workforce Commission. They have a rehab division, and we'll be talking about that a little bit more today as we talk about the more complex and discuss how catastrophic claims are managed. So let's move into part four. So our objectives today, we're going to talk about temporary versus permanent benefit claims. Most of our claims, and almost 90% of our claims, are going to be temporary claims. Those are your medical onlys. Those are the ones who go out for a few days, come back to work. Those are going to be the type of claims where we have any type of injury, but we have a impairment rating less than 15%. Those type of cases, and then we have supplemental income benefit claims, which are also a temporary benefit claim. And we'll talk about that a little bit more broadly because there is an opportunity for the counties to actually impact even though more serious claims from an employment perspective. We will talk about lifetime income benefit claims and death claims, which are actually permanent benefit claims, and then how we manage those claims, and then what your responsibility as the employer in order to be able to facilitate those claims until they're outside of your employee venue. These are challenging. This is where you have you have a journey that you plan to have a good start and a good ending, but sometimes the ending is not that great. And you have to pivot and you have to make adjustments and you have to find solutions to continue on that journey. And sometimes that journey doesn't end until maybe the death of the employee. We have to have reasonable outcomes, and we sometimes are not going to be good outcomes. So we'll talk about that as well. But it's going to require empathy, patience, and a lot of understanding. Sometimes we get into some very difficult situations. Employer gets into difficult situations because they have to make tough choices from an from a personnel perspective. And the workers' compensation side makes very difficult situations on how they're going to manage a claim and make sure that, number one, we're meeting compliance requirements, we're taking care of needs of the employee's medical condition, and then be able to look forward to whether the solution that we're going to have to put in place is going to be a month from now, a year from now, or 20 years from now. So I'll be honest with you up front, this is probably one of the reasons why I enjoy handling claims. Not because I like dealing with these catastrophic cases, but this is where you see really where the human side of the workers' compensation program really reveals itself. Because if you go to the next slide, you never know how strong you are until being strong is your only choice. And when you have a catastrophic case, when you have someone who's had an injury that's so severe that it's going to impact not only the quality of their life and their ability to function, but also the quality of their family and their friends and how they interact around them, the fact that they're going to have a permanent impact on their ability to earn their income, and then how it impacts your workforce. Sometimes you only have very, very few choices, and it can become very, very difficult. It can be heartbreaking at times. These are some very difficult times in workers' compensation, but again, this obviously can be some of your most fulfilling moments in doing this type of important work for your member employees. So this quote is attributed to Bob Marley, and to me, it's a very universal message that will apply to claims administration in this situation. So, reminding you that workers' compensation is the only coverage that's provided by the pool that's regulated with the Texas Department of Insurance. The Division of Workers' Compensation operates the workers' compensation system, and there's rules in place in which we must follow. We know we want to approach a claim from a very compassionate perspective, but we do have rules that we must follow. Sometimes they come in conflict with each other. Never will you see that be more an issue than you do with catastrophic and complex claims such as these. Because if you break the rule for one, you have to break the rule for everybody. And when you have a very emotional, impacting scenario, it's sometimes very difficult to stay compliant and stay within the lines. The DWIC is empowered to enforce this compliance and can issue penalties and fines if we do not follow appropriately. We are currently undergoing an audit with the Texas Department of Insurance for the administration of lifetime income benefits and death benefit claims. They take these lines of coverages very, very seriously. So I've listed these goals in the first three presentations. The goals that are set forth in the Division of Workers' Compensation are really four. An employee must be treated with dignity and respect when injured on the job. It sounds, that sounds like that should be a very reasonable concept that would be everyone should universally attend to. Unfortunately, some of the reasons why we have the Workers' Compensation Act and some of the compliance issues that are put in place is because employees sometimes are not treated with dignity and respect. They must have access to fair and accessible dispute resolution process that is actually administered through the Division of Workers' Compensation, and then have access to prompt, high-quality medical care. This is the reason why we have a network in place through a 504 network in place through the Alliance in order for us to be able to gain access to medical treatment and to receive the services to help an employees return to work. Now, returning to work, we talked about that a lot in part 3, because the division is very focused on getting employees back to work, getting them back into the workforce. That is a huge goal. We don't want people getting on workers' compensation and then becoming unemployed. That's really untenable. That's not the way the system is supposed to be designed. The reason I have the 2 highlighted, treated with dignity and respect with energy on the job and having access to prompt, high-quality medical care, it will just make sense that that will apply to your catastrophic medical case management claims. And then, of course, dealing with death claims, the dignity and respect aspect, that should be unspoken. Just a reminder, workers' compensation is a no-fault coverage. The compensable injuries qualify for lifetime medical treatment, 100% with no deductible copay or out-of-pocket expense for the injured employee. If you have a situation where an employee is saying that they're having to pay for anything for their treatment, please be sure that you contact the adjuster, their supervisor, or myself to ensure that we have the employee, no, they're not paying anything out of pocket. The lifetime medical treatment is really what I'm highlighting here, is that regardless of how serious that injury, what type of treatment must be provided, what type of arrangements must be made for the employee depending on their mobility and their ability to do daily functions. It's not about cost. There's no statutory limits for workers' compensation is infinite. It doesn't matter how much it costs. We are required by statute to provide that treatment. So, and that is for the lifetime for medical treatment. So if a very young employee who has a very serious injury, and it's not going to be a terminal condition for them, you could see potentially, multi-million-dollar claim. Our highest claim for reserves for a gentleman who recently died about a year and a half ago, he had almost $10 million. Just to give you an idea, the pool is committed to ensuring that our employees are taken care of with their workers' compensation program. All right, so we are getting ready to complete this journey. So let's get started. All right, so I mentioned earlier, we were talking about our goals for today. We have temporary and permanent benefits. So the claims that we're going to be talking about most of the time when we're having an interaction on telephone, or through emails, or you're communicating with your adjuster, are going to be your temporary benefits. Those are the temporary income benefits, impairment income benefits, supplemental income benefits. Of course, most claims are going to be TIBs. A little bit more severe claims are going to be IBs, and supplemental income benefits are even going to be a smaller subset. So to give you an idea, from a workers' compensation metrics perspective, medical only claims, those are claims where an employee has less than 8 days of disability. There's a 7-day waiting period. They return back to work within those 7 days. That's considered a medical only claim. That is about 75% of your claims for the entire pool. 75% of the claims are going to fall under that category. So that kind of gives you an idea about, okay, we've got people going back to work, they're getting their treatment. Many times they just go to the emergency room, they're one in and one out. That is going to be pretty much move that 75% out of the way. And then you have impairment income benefits. Now those are going to be people who have serious enough injury that there's going to be a permanent impact to their body. They have back surgery, they might have a 5 to 10% impairment rating. They have a knee injury, they'll have somewhere around 4 to 8%. They have an ankle injury, somewhere between 1 to 3%. Minor strains in here is you're going to see injuries that are going to be less than 15% of impairment. Those are going to fall basically about the next maybe 10% of claims. You're just not going to see a lot of them, but they do they're more costly. They're gonna last longer. They take a lot more time. There is really more of a trying to get them back into the workforce. A benefit that allows, if they're over 15% and you're moving from the impairment income benefits, which is about 10% of those claims, moving into supplemental income benefits, those claims are going to be another 10% of your load. And then you look at the permanent claims. That's your lifetime income benefits and your death benefits. Those claims are going to be the balance of of your claims, but that is a very small subset. Give you a holistic idea. If you look at the claims that we have that are considered legacy catastrophic cases that are over 5 years old, that is about 78% of our open claim volume now. Right now, we're looking at about 1,200 claims that are open for the pool. So about 78% of those are going to fall in the category of either supplemental income benefit, lifetime, or death benefit. And those are going to be the large loss claims. They're going to be really fall into the more catastrophic type of claim scenario. But that only, I apologize. 78% of the cost associated with those that 1,200 claims are associated with supplemental income, lifetime, and death benefits. I apologize. I inverted those numbers. But the supplemental income benefit, the lifetime income benefit claims, and the death benefit claims come to about 12%, 22% of the claims that are balanced. So you see a amount of the cost going towards the SIBs, the LIBs, the DIBs, which makes sense. But those are long-term management cases and they take a lot of time to manage. All right, so in prior discussions, we talked about navigating twists and turns with the TIBs. What you see on this presentation is what most of you already know. The goals are to return to work full duty with a pre-injury average weekly wage. On the next screen, we talk about IBs. We have same thing. Most of y'all have probably had some familiar with an employee who's had to take to receive impairment income benefits. They get a rating. They get a DWIC 69. They can dispute it if they wish, and we can adjudicate it. They're rebuttable, and then like I mentioned here is the cause of most of our disputes. But if it's less than 14%, then they receive their benefits. Most of them can go back to work, return to work to full duty. And then, we want to get them back working their pre-injury wage so they can move on with their life, and then they can terminate their medical care. So if we go to the next screen, we talk about SIBs, and we haven't dived into supplemental income benefits a lot. But if we have an employee who has greater than 15%, if they have had a knee replacement, a shoulder replacement, they've had multiple knee surgeries, particularly if you're dealing with bilateral knee injuries, bilateral shoulder injuries, if you have someone who has had perhaps multiple back surgeries, they may get greater than 15% if they had a traumatic brain injury, or even PTSD, a respiratory condition injury like with COVID. We're seeing lots of those greater than 15%. Those probably are not going to be able to bring them back into the workforce. Most likely, we might have someone who had an amputation where they can come back to work, do their jobs. But the ones that are unable to come back to the workforce, and from an employment perspective, either you're unable to maintain their job or they have to transfer into another position where they make less money, then they could be working through the supplemental income benefit period where they can actually apply for jobs. It works a lot like unemployment, where they have to show that they're actually looking for a job that's within their work restrictions. And if they're unable to find a position that meets their pre-injury average weekly wage, they can receive supplemental income benefits to whatever wages they're already receiving. And then that could take them up to 401 weeks from the date of the injury. So the goals here is to get them back into the workforce. Transferable job skills, we make those, we identify those, and we want to get those set so that we can move them into a rehab employment search. So takes a lot of time to handle those claims. Unfortunately, depending on the economy, it's not very successful sometimes if the economic situation is really not looking to put people back to work. It's also difficult for, for a state like Texas that has a lot of rural application, getting people back to work in rural settings. Sometimes we've had people who've actually moved from one county to go to a more metropolitan county, so that they can actually find a job in which that they can get themselves established, so they can maintain and grow in a position so that they can take care of their family. That can happen as well. So when an employer or a county can actually bring someone back to work in a setting, maybe making less money, we see this occasionally with law enforcement who are unable to go back and to do their full patrol duties, is optimal, but it doesn't happen very often. I think if the economy would improve, we saw lots of, about 15 years ago, we saw a lot of people moving under the supplemental income benefit program to go find better jobs. It hasn't been very successful in the last 10 years. So as I mentioned, temporary income benefits are TIBs, IBs, and SIBs. The maximum you can receive is 401 weeks. That's about 7 years, 8.5 months. Starts from the date of the injury, and when 401 weeks is ended, that's the ending of a workers' compensation indemnity benefits. Those are the income replacement benefits that we pay weekly. That is it. By statute, they can get no more than 401 weeks. Go to the next slide. Kind of gives you an idea. The full 401 weeks, 104 of those weeks, you've got a 1 out there to the left of that screen. That first week is a waiting period. Under the statute, the waiting period is not even a temporary income benefit week period. It can be reimbursed after being off work for 14 days. But the first week is called the waiting period. Just as simple as that. The next 104 weeks are the temporary income benefit weeks. When they get to the end of 104 weeks, and temporary income benefits will stop regardless of what their medical condition is. They will be at statutory maximum medical improvement, and an impairment rating would have to be assigned. By then, the adjuster should have already sent them to a designated doctor to be evaluated, but the adjuster does have the authority under the DWIC rules to assign an impairment rating, then send them to a designated doctor to start benefits. So for someone who has reached maximum medical improvement, it has a 15% impairment rating. If they had 15% impairment rating, they would receive 45 weeks of impairment income benefits, because you get 3 weeks of benefits for every 1% of impairment. And then when that 15% weeks is up, they would be eligible for supplemental income benefits. So you see that 251 block there, that's a large amount of weeks. That should be a lot of used very carefully to get someone back into the workforce incrementally. So if you bring somebody who was making $1,000 a week, but they are coming back to work into the workforce, they can only make $750 a week. The objective is to try to get them to make that money up during that 251 weeks. That was the objective. It hasn't been, I don't think it's been as successful as the Division of Workers' Compensation would expect it to be, but there is a framework in place with cooperating employers in order to be able to get people back into the workforce if they're able to use their skills, transfer them to another job, recognize that they just have to kind of start over again and work up through the system, with the benefit of having the supplemental benefits to help them bridge themselves over into a new employment atmosphere. So this is an example of temporary income benefits, and I hope that explains it fairly well. So we're talking about reaching the journey's end. So if you looked at that previous slide, and you can see a beginning to the end for someone who falls within the category of temporary income benefits, We have a lot of employees, though, who continue to have medical treatment after that. So even though they might have arrived and they've landed at the end of where their indemnity benefits are, they may continue to have chronic health issues and chronic pain management issues all the way through to the end of their life. And those cases, while they may not necessarily qualify as a catastrophic scenario because they're just dealing with back pain or things along those lines. They do actually, those cases can be pretty pricey, and we have to monitor them very carefully because obviously if you're dealing with a lot of prescriptions, there can be some bad outcomes if those are not being monitored correctly. We have a pharmacy management program with our for our prescription benefit management program, we got a pharmacy management program and a formulary in place to ensure that those cases are being managed very carefully. So now we go to permanent benefits. This is where everything changes. So case that came out in 2011, they went through the full adjudication through the workers' compensation system and actually went to the Supreme Court. Lifetime income benefits are the greatest of all benefits an injured worker can receive. Lifetime income benefits are probably where we will see the largest reserve buckets. You have someone who is catastrophically injured, they can actually within a month generate over $1 million in medical care. And then after you think about long-term care, you think about everything that's required for everything from the home health to the facilities that they might need in order to be able to recover, accommodations that need to be provided. And then moving out into the future, you're easily looking somewhere between $4 to $6 million on a claim in today's world. So, it's important. I mean, it's important that we have a benefit program in place. And of course, these programs are defined through the state legislature and through what has been, with the Texas Department of Insurance, the statutes and the rules that are managed through the Division of Workers' Compensation. It's important that we have these benefits. So benefits are paid into the death of the claimant, and those are specific to the income benefits, to the indemnity benefits. The claimant can continue to work and receive libs. I am familiar with a lifetime income benefit case with a large insurance carrier that was up in the Dallas area, where an employee was involved in a very, very serious motor vehicle accident and had a spinal cord injury, which rendered him to be certified for lifetime income benefits. So this was a high wage earner. So the benefits themselves are 75% of the average weekly wage, but there is a cap on the initial benefit year. And this was a high wage earner. So even the lifetime income benefit was not going to sustain this employee over a long period of time. But because you develop relationship with these employees and you get to know a lot about them, the insurance company that was actually handling the claim for this employer ended up hiring that employee on staff. He actually went to work for them in their insurance department and was considered a very high valued employee. He was continuing to receive his lifetime income benefits and receiving his salary from the insurance company for the work that he was being done. This information was shared with me through my association with the Dallas Claims chapter. And I thought it was quite inspirational to see how you have a program trying to bring someone to make him whole. This is where a carrier actually stepped in to do it with working with the employer as they transferred that claim over. But it also shows that, if someone has lifetime income benefits, there is hope in the future if they are willing to go back to work and to try to do the best with a bad situation. These lifetime income benefit payments are increased 30% like a COLA each year from the date accrued. The date accrued for lifetime income benefits is the date that a medical provider, qualified medical provider, makes a determination that the injury that the employee has qualifies for lifetime income benefits. It's not necessarily the date of the injury. There is a application process for lifetime income benefits. The employee has to provide a written request for benefits. And then the carrier has 60 days and 90 days to respond with a what's called a PLN4. And then there's no negotiation on it. There is a situation where the carrier doesn't agree to pay lifetime income benefits, it has to immediately go to a hearing. Now, once the benefits start and they continue 3% every year as life goes on, time goes on, statutory maximum cap does not apply. So if someone is getting 3% and it's going to be higher than what the cap is for the following year, it continues on its own ladder. It does not follow the statutory maximums that are applied to the other benefits. So these are the criteria for lifetime income benefits. What you'll notice that the first one's obvious: total loss of sight in both eyes. You can see the challenges of trying to bring someone back to the workforce if they've lost their sight. Those some very inspirational stories associated with those type of injuries. Lots of interesting applications of treatment and therapy. And a lot of that therapy is not really covered under the utilization review guidelines of the workers' compensation. So you have some flexibility on how you can manage those type of claims. When you have loss of feet, hands, above the ankle and above the wrist, it's because the amputation has to include the joints of the ankle and the wrist in order for it to be applied. Spinal injuries, if it results in permanent complete paralysis of the legs, and what we mostly see, like with motor vehicle accidents, where we see a severing of the spine, or even at the lower back, where it'll affect both legs, or at the neck, where it'll affect it, maybe more of a quadriplegic approach. Those are obviously. Now, what's a little bit next, if you look at I guess it's about the sixth, 1, 2, 3, you got the sixth bullet point down: permanent complete paralysis of both arms, both legs, or one arm and leg. That is a little bit different because that's called the C-bolt, and we'll talk about that in just a moment. You may have someone who did not have a complete, complete injury, insult to the spinal cord, and they still have a little bit of movement. This can get a little tricky because how you can function, even if you have a little bit of function at all, becomes a gray area. And we have to get into some legal discussions on whether or not it qualifies as paralysis as itself. Traumatic brain injury, this is a recent change of legislature in 2023, actually changed some of the wording on workers' compensation. We had some probably less, I want to say that it was less kind words that were used in the previous statute. So they actually changed it to be a little bit more clarification to a permanent major neurocognitive disorder requiring supervision in routine daily tasks, but rendering them permanently unemployable. And so now you're seeing the employment issue to fall into lifetime income benefits as far as qualifications. That wasn't part of it until about 2023. Prior to that, you had a physical criteria for meeting lifetime income benefits. Now the employment situation is an issue, and that's specifically going to affect law enforcement, and we will talk about that in just a few minutes. And then finally, third-degree burns covering 40% of your body, but it has to require grafting. Now, I will tell you, for every claim I've ever had with third-degree burns that had so significant that you had 40% of the body affected, they've always required grafting. And then third-degree burns covering the majority of either both hands, one hand, one foot, one hand, and the face. That is because of scarring. It does significantly impact function. And so those injuries can also result in lifetime income benefits. Again, these injuries, if you think of them from maybe a higher level, you can say, okay, someone could have these injuries and they could probably work. So if you receive lifetime income benefits, you can still work. The Seabolt test. The Seabolt test was loss of use and employability. That's where the employability issue comes in. Way back in 1962, but it wasn't really used and applied to lifetime income benefits as aggressively as it has in the past 5 to 10 years. And this really has to do with first responders, where we were seeing most of the litigation that finally has landed into the legislative process, where we're seeing what we have for the criteria today, was that if someone meets the criteria, but not quite meets that criteria, but they're unemployable, it's the same outcome. If they physically cannot go back to work because of that injury, and they cannot maintain employability and be able to maintain their lifestyle and their family's financial outcome, should they be qualified for lifetime income benefits. In other states, there is application of what they would call temporary total benefit, total disability, and we really did not have a solution for that in Texas. So this kind of bridges that gap. So if you skip down to the fourth bullet on this particular slide, we talk about serious injuries for first responders, and this is for date of injuries after September 1st of 2023. Serious bodily injuries could actually fall under lifetime income benefits, and the way that they're defined is that first of all, you have a serious injury that's going to prevent you from having normal function of major bodily organs, your limbs, your hand, your arms, your legs, having something that's going to provide you to the point where you're going to have that daily supervision, and that's going to render you unemployable, and then it's permanent, and that all has to be defined. And so we're actually utilizing a bodily injury code from the Texas Penal Code to the Workers' Compensation statute, and that was really kind of came from the firefighters with some of the injuries that the firefighters had, to show that they should be qualified for these lifetime income benefits, because sometimes injuries can fall outside of that criteria because they're kind of an outliers, and there was really no option for outliers, and this is where the outliers are going to fall. Now, there are going to be some criteria for these. They have to have an annual certification for employability, and the pool can look for LIB entitlement every 5 years, and they can suspend if they fail to submit to an annual certification. So this separates it from all the other lifetime income benefits, because with everything else, if you meet the criteria, the strict criteria, the physical criteria for the benefit, you get those benefits and you can never not get them again. I mean, once you get them, you always have them. But under the serious injuries for first responders, to get those lifetime income benefits, if they improve over time, or we find something that they can do, then actually, unless they meet those strict criteria, we might actually be able to terminate their lifetime income benefits. And this is, I think, where we kind of eliminate some of the fraud, malingering issues that might come in. So again, handling these cases can be a little tricky sometimes. They can have twists and turns. Now, the two middle bullet points that I did not address: imbecility and insanity. Those are the two words that were used in the act prior to September 1, 2023. I think during COVID, we were looking at all of these rules and making sure that people were being more sensitive to some of the language that's in the legislation. And so that was changed to the major neurocognitive disorder. And I will tell you that our legislative department here at TAC was involved in the language along with Texas Municipal League and Texas Association of School Boards, their pools, or in the language used for the major neurocognitive disorder language that's down in the act. I think it's a little bit, it speaks more to our contemporary times and at where the science is for treatment in medical conditions right now. So death benefits. A few of you have unfortunately had to deal with death benefits because we've lost an employer in either in line of duty as a first responder, or we're involved in a tragic injury in the course and scope of their employment and the other disciplines with the counties. Death benefits, that the rate is 75% of the employee's average weekly wage. So we need all the DWIC threes, we need all the prior, health insurance information, all that, as we had before. They're paid to the legal beneficiaries. That's where the tension is on the claim, because the claim shifts from being an employee claim to a beneficiary claim. The application of benefits at DWIC 42 has to be filed within 1 year of the employee's death. And the legal beneficiaries can be wide. They can include the spouse, child, grandchild, or other dependent. And then if there are no legal beneficiaries that are included in that dependency category, then non-dependent parents may be a legal beneficiary, and they can get up to 104 weeks. Benefits are if we do not pay someone beyond 364 weeks on a claim, then the balance of that 364 weeks are paid to the subsequent injury fund. That program is really important because we do get reimbursement for them for like secondary injuries. We'll talk a little bit about that in a minute. And then burial benefits are $10,000 of the actual cost, whichever is less. From your human resource perspective, if you have someone who unfortunately has a death on the job, and you're talking to the family, and it's an obvious claim, sharing with them, they may ask you what benefits you have. Workers' compensation is a benefit program. Obviously, we pay death benefits on compensable injuries, but we also have burial benefits that if we pay for $10,000. We want to make sure that those are taken into consideration when the family and the loved ones are making arrangements for your employee. So we have a lot of drama associated with death benefits sometimes. It's one of those kind of cases where people, we have a surviving spouse, and then we have to do an investigation for benefits. We usually will engage a field investigator to do that. Some of you have actually worked with a field investigator on some of these cases, but we have to sort out who are the proper beneficiaries, because we need to get it right the first time. Sometimes multiple wives will show up, multiple spouses will show up, and we have to sort through that, find out who is the surviving spouse. Like I said, there can be a lot of drama. Sometimes children will show up that out of nowhere. Common law spouses may be eligible by proving evidence of common law marriage. The family law is interesting in Texas. Common law marriages can be recognized. There is a process to do that. There is a case that's moving up towards the Texas Supreme Court that's challenging some of the common law issues. So we'll be anxiously watching that, because we have more common law Texas now than we probably had 20 years ago on some of these cases that pop up, but they can receive benefits. Abandonment of marriage must show separation for no good cause for 1 year prior to employee's death. That's something that we do have to investigate more than you would think. Surviving spouse of the first responder is entitled to benefits until death, even if they remarry. A surviving spouse of a non-first responder is entitled to benefits until death, unless he or she remarries, because upon remarriage, the spouse receives what we used to call a dowry, but that's not a very good word anymore. We call it a holiday now. Will receive 104 weeks of death benefits. And so if their children are involved, it may, there's benefit, 50% would go to the children, 50% would go to the spouse. The spouse could receive their 104 weeks of death benefits. And then when that 104 weeks of holiday expires, then the children would receive 100% of the benefits. So that's kind of how it works. So the subsequent injury fund, think that when I mentioned that if we don't pay 364 weeks of death benefits, we pay money to the subsequent injury fund, which is the state. You think, why would you want to pay the state? Well, the reason we have a subsequent injury fund is really unique history. Um, when military veterans came home during World War II, I mean, we had a lot of people coming in from World War II looking for jobs. And these employers were concerned about the exposure to paying lifetime indemnity payments by hiring an employee who had a pre-existing condition, because you had a lot of military veterans that were coming home with loss of limbs. Um, you know, if someone had an amputated arm and they wanted to go work in a manufacturing plant, there was a great concern that well, what happens if they lost the other arm? If they lost both arms, they would be exposed to lifetime income benefits. So what the subsequent injury fund was, establish a process where that if someone was injured and unfortunately had the loss of both limbs, one from military service and one from working on the job, then the carrier would only, or the employer, the carrier would only be responsible for the injury which was causing the compensable injury. And then, but the employee would still be qualified for lifetime income benefits, but the state would pick up the balance. So if we had someone who had lost an arm and they had a 60% impairment rating under a workers' compensation claim, they would receive benefits. They'd receive their temporary income benefits. They would receive 180 weeks of impairment income benefits, and then possibly receive the balance of the SIBs if they were not back to work. But then the state would pick up the lifetime income benefit portion and pay them directly. So it's a cooperation between the employers and the state to honor and to bring these veterans back to the workforce. This has been successful, and therefore we have the subsequent injury fund. And of course, it is funded with these death benefits that can't be claimed because of the criteria under workers' compensation. So it's a very good, and it's not just for Texas, other states have it as well. We used to call it the second injury fund, but now that changed with the new act, calling it the subsequent injury fund. So when a catastrophic injury occurs, to give you some cues. Seek emergency acute care for your employee. If necessary, emergency transport immediately. Don't think about cost, don't think about network, only think about what must we do to take care of our employee. The details can be worked out later. Lead with empathy. Even if you don't like the employee, lead with empathy, or you think the claim, whatever happened, was stupid or whatever. You have to lead with empathy, because you have to set those emotions, those immediate emotions aside, and just take care of the medical needs of that employee. Attend to that coworker or that employee as a family member. That is your best way to approach it. That actually gives you the freedom to make those decisions and not worry about any of the other noise around you. The Alliance Network status for those counties that are mandatory for the Alliance. The Alliance Network status is not a requirement for emergency acute care. So that doesn't even have to be part of your decision making, because once you get them into the emergency acute care, then we should be able to pick it up from there. Notify the pool immediately to create a claim and trigger assignment in nurse case management. If you're using the portal to report claims, report it immediately. If it's a catastrophic injury, I would appreciate notification so I can make sure that we've got all the boots on the ground to take care of business of taking care of that employee, because a lot of things move very quickly on these type of injuries. So you want to gather information as soon as possible so we can get a family contact, because many times these employees are unable to communicate or advocate for themselves. We particularly want to have information if we've got a law enforcement officer that might be involved in a high profile case, because many times they will be admitted into the hospital under an alias. In order for us, our nurse case managers, to do their job, to be able to kind of slide in under the radar, to have access to the physicians, to get the medical information that they need to ensure that we've got all the proper care in place, and to connect with the family members from in the backside. we would need to be able to get the information, and many times we need to get authorization from the sheriff's office to gain access to those providers and to assist with that treatment coordination. That can be tricky. We're not going to be pushy. We're not going to demand that we come in, but any cooperation that we can get from the county to ensure that we've got our boots on the ground to take care of business. A lot of decisions have to be made. Sometimes people have to be transferred to other facilities, things along those lines. These facilities and these transport providers want to make sure that they've got payment authorization. And this is where the pool can really step in, make things move a lot smoother for the family, assure them we know we take care of, there are some things that we do to take care of family during that period of time as well. And so we want to be helpful, but not hurtful though. So if we will maintain whatever boundaries that the counties have set up on those type of scenarios, but just be prepared to visit with us so we're not in the dark. So we're prepared to coordinate when we can step in. So medical care for these type of claims are managed by the admitted physician. So if they go into say a major acute setting, whoever admitted them is going to be driving the train within the hospital. And they will be coordinating that care across all the medical specialties and disciplines. The nurse case manager coordinates with the admitting physician and with the social worker at the hospital in order to be able to gain information so we can make decisions on the way the treatment is going to go. Field and nurse case managers work with that hospital personnel to facilitate specialized care. The field case managers actually will visit and work with the families as well to ensure that everybody has what they need in order to be able to support and advocate for that employee. And then of course, once they finish their acute care in that hospital setting, they may have to go into a skilled nurse unit or into a rehab or into a long-term care facility. They tend to refer them like at 5 o'clock on a Friday afternoon, which is always very difficult. So we need to have all of those people working on that case so that we can make those transitions even when it's a difficult time, particularly around the holidays. Now, these treatment plans can pivot often. People, they advance. They look like, people can be in care and then everything's going great and then all of a sudden there's a regression. It's almost inevitable with the most serious injuries. And, employees and the family become very weary and frustrated. These issues can escalate and they can escalate quickly. And they get to know our nurses, they get to know the adjusters, and all the drama seems to unfold and it bubbles up. And many times the employers are aware of it as well because everyone is involved and everybody wants to help. But the reality is this is when we have to be on our best behavior. We have to stick together in order to be able to support these employees and move them forward. Workers' compensation is committed to lifelong care. Going back to the beginning of our presentation, when I mentioned that we have lifetime treatment and we pay for lifetime treatment. This is for the long term. We just don't get in and get out. This is for the long term. Disability benefits may change the financial dynamic of the family, and the whole family structure can break down. I cannot tell you how many times I have witnessed families deteriorate, divorces ensue, and we have someone who's seriously injured and they end up alone when at the end day. It can be very tragic sometimes, but the adjuster, the pool, the case managers will stick with that employee all the way through the end. I mean, their employment status may change. Many times I'll be in a claims review with a member county, and we'll talk about a claim and they don't know who that employee is because that employee was injured many years ago. We stick with that employee through that entire process. That's why we're here. That's the reason you've got coverage for workers' compensation. And the way the pool approaches our claims is that employee was as important to us on day one of their injury as it is to the last day of their claim. Many of these claimants lose the support of families and friends, and we recognize that and we see that sometimes as time goes by. But there are some remarkable stories, and I wish I'd had enough time today to share some of those stories with you. So sometimes when you're really, really interested and you want to be bored by one of my stories, I can pull one of those out of my hat. So every claim is handled on its merit. We want reasonable medical outcome with the cooperation of everybody. We do have a pool. We have a new tool I want to share with you. It's called Paradigm. At some point, I would like to share this with you a little bit more, perhaps in another setting, at a regional conference or maybe at CMRC or sometimes. But Paradigm is a company that acquired Best Doctors. That's a panel that has talented physicians all over the country that specialize in certain type of diagnoses, and they can provide guidance. They can actually do oversight. In most hospital systems in the state of Texas, embrace their involvement. Our excess carriers are really supportive of us using a program like that. They've had some remarkable outcomes with their programs, and we now have access to them through our excess with our reinsurance carrier and our excess carriers. I'm real excited about that. Fortunately, we've not had to use it. We want to not ever use them, but we do have access. So I'm really excited about having that for our employees as another level to advance their claims. So employer responsibilities. Attend these trainings. I seek and attend these trainings. Anytime you have an opportunity, be alert to any changes in our workers' compensation system. Report your claims immediately. Prepare your forms thoughtfully and timely. If you have a question about how a form should be prepared, contact me. I will give you a one-on-one form training. Provide post-injury income when requested to ensure benefits are paid accurately and timely. We have a duty to ensure that our employees are being paid according to the Workers' Compensation Act statute and rules, and we want to make sure that they're taken care of. We never want to underpay an employee. Separate your personnel issues from your workers' compensation claim. That's the reason we work so closely with our HR consultants for guidance. And maintain contact with your handling adjuster, advocating for the employee and monitoring claims. Contact me if assistance is needed. So if for some reason that communication is broken, contact me immediately. That needs to be repaired so that we can make sure that the employee is not going to be compromised in their claim because of an administration issue. So in conclusion, in a catastrophic scenario, if you have lifetime income benefits or death benefits, and I'd actually pull some of those supplemental income benefit claim files in there, it really depends on a team approach. It's not something an adjuster can do by themselves. It takes everybody. This is one of these situations that really does take a village. We all have to be together. And then the pool steps in to make sure everything's properly funded so that we can support all of the administration that's going into managing one of these claim files. There are some remarkable stories, and with Bob Marley's statement in the early part of that about sometimes there's no choice. When people are pushed into a corner and they have nowhere else to go, some remarkable things can happen. I've seen some amazing stories. I've seen tragic stories, and I've seen some very inspirational stories come out of these cases. So, until an employee requires no further care and the last bill is paid, our journey is really not yet finished. So, thank you for participating in these programs. If you'll go to the next one. I want to share our human resource consultants. I throw their names up there all the time because I am using their names all the time. They're heavily involved and integrated in our workers' compensation programs to ensure that we are not breaching into the employment aspect of it. And finally, I just want to go to the last screen and tell you thank you. It's 11 o'clock. Thank you so much for joining us today.
Thanks, everyone. I'm going to keep it open here for a second because I had told you guys that I would show you the link to I would give you the link to the webinar archives where you can see the recordings of our previous webinar. So I'm going to put that in the chat right now. And then also, open it up for questions if anybody had any questions. Helena's so good at explaining everything that she doesn't get a lot of questions because she explains it so well the first time. But you should see this link in the chat that has that's our webinar archives page. And you can see the recordings of not only this series of webinars, but also all of the webinars that we've had this year, you can see on that webinars archive. And again, don't forget, if you want a copy of the slides from this presentation, it would be in PDF form. You can email tacrcs@county.org to request that, and I can get that over to you. But again, thanks so much, everyone, for coming today, and hope to see you at a future webinar.